All right, peace and blessings, everybody. It's August 30th, the year 2017. We have a document that was put out by the Ninth Circuit. I was sent the link and I downloaded it from the Ninth Circuit. So the top of the document says not for publication, but they have already published it. So I don't know, somebody must have forgot to take that off because they're the ones who published it. It says filed yesterday, August 29th, the year 2017. I have not read this. Let's read it together. Not for publication, United States Court of Appeals for the Ninth Circuit. United States of America, Plaintiff Appellee versus Francis Schaeffer Cox. Number 13-30,000, DC number 3:11-CR-00022-RJB-1 Memorandum. Appeal from the United States District Court for the District of Alaska. Robert J. Bryan, District Judge, presiding. Argued and submitted August the 16th, 2017, Anchorage, Alaska. Before Graber Clifton and M. Smith Circuit Judges. Defendant Francis Schaeffer Cox appeals his convictions for conspiracy to murder a federal officer in violation of 18 U.S.C. Section 1117 and 1114, and for solicitation to murder a federal officer in violation of 18 U.S.C. Section 373 and 1114. We affirm defendant's conspiracy conviction. Well, that's bad right there. You know, I don't like that statement at all. Vacate his solicitation conviction. That's a step in the right direction. We affirm... Okay, hey, babe. Hold on just one second. All right, I had to take the phone away so that don't interrupt me anymore. We affirm defendant's conspiracy conviction, vacate his solicitation conviction, vacate his sentences, and remand to the district court for resentencing. This disposition is not appropriate for publication and is not precedent except as provided by Ninth Circuit Rule 36-3. You know, they say it's not appropriate for publication, but they're the one who published it. I'm just reading it. All right, so sounds like they're going to resentence him. So rather than get 26 years, they may resentence him to something less than that. So we praise God for that. It is a step in the right direction. Number one, defendant challenges several aspects of the jury instructions. First, he argues that the instructions failed to inform the jury that it had to find that he conspired with mental state required for first-degree murder in order to convict him of conspiracy to commit first-degree murder. Reviewing for plain error, we conclude that any error in that instruction did not affect defendant's substantial rights. United States versus Olano, 507 U.S. 725-734-35, 1993. Second, defendant argues that the instructions were deficient because they did not inform the jury that it had to find the conspiracy was not... Let me read that again. Second, defendant argues that the instructions were deficient because they did not inform the jury that it had to find that the conspiracy was not one for self-defense. We conclude that even assuming that the defendant has preserved the argument, the instructions adequately covered his theory of self-defense. United States versus Gomez Osario, 957 F.2D 636-642-43, Ninth Circuit, 1992. They were not misleading. Stoker versus United States, 587 F.2D 438-440, Ninth Circuit, 1978, per curiam. And the district court did not abuse its discretion in formulating the instructions as it did. United States versus Knapp, 120 F.3D 928-930, Ninth Circuit, 1997. Finally, defendant argues that the lack of an instruction to the effect that the jury had to agree unanimously as to the targets of the conspiracy confused the jury. Reviewing for plain error, we conclude that it is not obvious or clear that the district court erred by not giving a specific unanimity instruction to the intended targets of the conspiracy. See Puckett versus United States, 556 U.S. 129135, 2009, noting that for an error to be plain, it must be clear or obvious rather than subject to reasonable dispute. Number two, defendant next challenges the sufficiency of the evidence on the conspiracy charge. We assume without deciding that That's interesting. We assume, without deciding, that defendant has properly preserved this challenge. So that is our review in de novo. See United States versus Phillips, 704 F.3D 754762, 9th Circuit 2012, we conclude that, considering the evidence presented at trial in the light most favorable to the prosecution, that evidence so viewed is adequate to allow any rational trier of fact to find the essential elements of the crime beyond a reasonable doubt. United States versus Nevels, 598 F.3D 1158 1164, 9th Circuit 2010, en blanc, internal quotation marks and alteration omitted. Defendant and his co-conspirators agreed to attack government officials, including federal officers, in the event of certain conditions that they subjectively thought were likely to occur. A rational trier of fact could find beyond a reasonable doubt that the agreement was not merely one for self-defense. A rational trier of fact could also conclude that the agreement standing alone constituted a sufficient threat to the safety of federal officers so as to give rise to federal jurisdiction. United States versus Fiola, 420 U.S. 671, 695 through 96, 1975. I don't agree with that statement at all. Number 3, defendant also challenges the sufficiency of the evidence on the solicitation charge. We review for plain error, but plain error review of a sufficiency of the evidence claim is only theoretically more stringent than the standard for a preserved claim. United States versus Flyer, 633 F.3D 911 917, 9th Circuit 2011, internal quotation marks omitted. We conclude that it is clear that no rational trier of fact could find defendant guilty of solicitation to murder of federal official for 2 independent reasons. First, no rational trier of fact could conclude that the circumstances surrounding the formation of the security team for the television station event strongly confirm that the defendant actually intended for anyone to commit first-degree murder. United States versus Stewart, 420 F.3D 1007 1020-21, 9th Circuit 2005. Second, because the federal hit team that the security team was supposed to guard against did not exist, the solicitation to murder a member of that hit team did not constitute a sufficient threat to the safety of a federal officer so as to give rise to federal jurisdiction. Fiola, 420 U.S. 695 through 696. The error affected defendant's substantial rights and seriously affected the fairness, integrity, or public reputation of a judicial proceeding. And we, number 1, the government's theory at trial was that the defendant's actions in connection with the formation of the security team for the television station event constituted solicitation to murder a federal official. No rational trier of fact could conclude the defendant's others' actions, those not related to the creation of the security team, amounted to solicitation within the meaning of 18 U.S.C. 373. Going back to the previous sentence, the error affected defendant's substantial rights and seriously affected the fairness, integrity, or public reputation of a judicial proceeding, and we will correct it. See Flyer, 633 F.3D at 917. When a conviction is predicated on insufficient evidence, the last 2 prongs of the plain error test will be necessarily be satisfied. Brackets omitted. Quoting United States versus Cruz, 554 F.3D 848-45, 9th Circuit 2009. Cruz, 554 F.3D at 845. Holding the last 2 prongs of the plain error test are necessarily met when a court, as a matter of law, had no jurisdiction to try a defendant for the alleged offense. Number 4, defendant next argues that several of the district court's evidentiary rulings were erroneous. Reviewing for plain error, we conclude that the court's decision to admit evidence about defendant's political speech and activities was not plainly erroneous, and assuming without deciding that defendant has properly preserved his challenge to the district court's rulings on his requested limiting instruction, we conclude that neither the court's particular formulation of the limiting instruction nor the court's refusal to give an instruction at the time the evidence of political activity was presented to the jury constituted an abuse of its discretion. See United States versus Campanelli at 518 F.2D 352-362, 9th Circuit 1975, per curiam. Appellants place special emphasis on the refusal of the judge to give cautionary instructions on the statements of co-conspirators at the time the evidence was admitted. The subject was covered at the conclusion of the trial. There was no prejudicial error in the judge's failure to give such an instruction also on other occasions during the trial. Citation omitted. 5. We decline to reach defendant's ineffective assistance of counsel claim. See United States versus Geronimo, 398 F.3D 1149-1155, 9th Circuit 2005. As a general rule, we do not review challenges to the effectiveness of defensive counsel on direct appeal. Overruled on other grounds by United States v. Jacobo Castillo, 496 F.3D 947 9th Circuit 2007 in Blanc. Number 6, we vacate defendant's sentences on all counts of conviction and remand with instructions to resentence defendant in light of our reversal of his solicitation conviction. See United States v. Evans Martinez, 611 F.3D 635 645 9th Circuit 2010, holding that an appellate court has the power to vacate all the sentences imposed by a district court when the district court erred with respect to one of the sentences, and remand all sentences is often warranted. Affirmed in part, reversed in part, vacated in part, and remanded.